Ladies and gentlemen, my name is Isaac Christopher Lubogo. Today we're going to make a very interesting discussion in light of a critical analysis of the legal takeaways from the popular case that just happened today, the Attorney General versus Honorable Michael Kawazikura, Constitutional Appeal number 2 of 2021. In light of what are the takeaways, how does it inform our jurisprudence for today? Listen, justice is not merely the application of law, but the alignment of law with fundamental principles of fairness, dignity, and human rights. So when military tribunals, encroach upon civilian justice, then the scales of justice tip dangerously towards arbitrariness, undermining the very essence of constitutionalism. So a just society must recognize that the legitimacy of the legal process is derived not from power, but from the adherence of the rule of law and the protection of individual freedoms. That is something important for us to start as a preamble. Now, ideally, the intention is to understand why the essence in terms of trying civilians in military courts and what fundamental breaches of justice are we likely to see in light of the legal frameworks in terms of how upholding human rights and the principles of constitutionalism, as the case may be. Today, we have witnessed one of the most fundamental jurisprudential discussions in this country. The Supreme Court of Uganda has delivered a landmark ruling declaring the trial of civilians in military courts unconstitutional. And this decision basically stemmed from a 2021 appeal by the Attorney General challenging the Constitutional Court that had actually previously deemed such trials unlawful. And the case was initially brought forward by former Nakawa MP Michael Kabaziruka, who actually contested his position in a military court on charges of treachery, not so. And that's the reason why we're here today. Now, the Supreme Court's ruling basically emphasized that subjecting civilians to military tribunals violates Article 28 of Article 1 of the Ugandan Constitution, which basically guarantees the right to fair hearing before an independent and impartial tribunal. So the court underscored that civilians should actually be tried exclusively in civilian courts to uphold constitutional principles of justice and fairness. Yeah? Important also to comprehend is that this decision has actually significant implication in terms of Uganda's legal landscape. It basically reaffirms the jurisdiction boundaries between military and civilian courts, ensuring civilians are not subjected to military justice systems that actually may lack necessary independence and even impartiality. So the ruling also aligns with previous judgments such as the 2022 Court of Appeal decision in the case of retired Captain Amon Biarugaba, which actually declared that military courts are not courts of judicature as defined by the Constitution, and therefore they lack the jurisdiction to try civilians. And that is fundamentally important, even as we decipher into the nitty-gritties of this case. So in the context of this recent event, the ruling is basically very poignant. Why? Because prominent opposition figures like Dr. Kizza Besigye have actually been facing treasury charges in terms of the general court martial. So it's issue that has actually drawn national, even international attention. So the Supreme Court decision could actually influence the handling of such high-profile cases, reinforcing the principle that civilians, regardless of their charges against them, are entitled to fair trial in civilian courts, including my former student Aaron Kizza, who happened to be the legal counsel for Dr. Kizza Besigye. Overall, the idea is that the Supreme Court ruling strengthens the protection of individual rights and upholds the integrity of Uganda's judicial system by clearly delineating the appropriate jurisdiction for civilian and military legal matters. And that is substantially important for us to take away again from the word go. Yes. Now, let's go a little bit deeper in terms of jurisprudence. The Supreme Court, in terms of this particular case, marks a significant milestone in terms of Ugandan constitutional jurisprudence. So the legal takeaways basically will help us provide a deep insight into the evolving nature of military justice, the protection of civilian rights, right, and the broader implication of Uganda's legal system. So I'm going to try to argue in terms of the evaluation of these legal ramifications in terms of concerning both local and even international provisions, so that you can understand why, the whys, the wheres, the who's, the hows, and stuff like that. Now, let's first of all contextualize our debate in terms of the legal status of the General Court Martial. The General Court Martial, others known as the GCM under the Ghana Constitution, first of all, is a subordinate court. That we cannot take out from that, right? And just like my friend, the Honorable Justice Mike Tibita, pronounced that the General Court Martial is a subordinate court under Article 129 of the Ghana Constitution, which aligns with prior constitutional interpretation that classifies military courts as part of the broader judicial structure, but subordinate to what? To civilian courts. And the legal basis for this is based on Article 129 of the 1995 Uganda Constitution, which establishes courts subordinate to the Supreme Court. Yeah, so the Court of Appeal, for example, the High Court, and this includes military courts among others. So that should be substantially important for us to take away from the word go. So the UPDF, or the Uganda People's Democratic Act, provides for military tribunals, but their jurisdiction must conform to constitutional boundaries. And that is something that you cannot deny or take away from the principles of constitutionalism. Yes? And by implication, we are saying that this ruling clarifies that military courts do not have absolute independence, and therefore they remain under the oversight of Uganda's civilian judicial system. That is super important for you to comprehend. So the decision of the General Court Martial can actually be subjected to judicial review, for example, by the High Court, which reinforces civilian supremacy over military judicial processes. And that is fundamentally important for us to comprehend again. Now, let's also make a discussion in terms of what they call the unconstitutionality of Section 117, subsection 1 or G of the OPDF Act. Yeah, and my friend, again, the Honorable Justice Chibita's ruling in light of Section 117, subsection 1G of the UPDF Act, argues that it is unconstitutional, null and void, and is a major legal development, and that's something fundamentally important. In terms of the content of the section, when you look at Section 117(1)G of the UPDF Act, it allows the military court to try civilians accused of offenses related to national security. And that's where he has an issue. Yeah? And that's where we're saying jurisprudence is finding what? Leverage in terms of a good thing for this country. So the provision has long been challenged as an overreach of military jurisdiction, and therefore looked at as a constitutional violation. When you look at Article 28, sub-Article 1 of the Ugandan Constitution, it guarantees that every person has the right to a fair hearing before an independent and impartial court. So military courts, by their nature, are neither fully independent nor impartial. That is something, again, important for us to comprehend, again, from the word go. Now, when you look at Article 210 of the Constitution, it limits military laws to members of armed forces, meaning their extension to civilian is unconstitutional. And that is something we must comprehend, again, from the word go. We cannot, again, run away from that. So the law, my friend, is catching up with you. Not so. Now, when you look at in terms of international perspective, the African Charter on Human Rights, on basically human and people's rights, yeah, the SCHPR, Article 7 guarantees that the right to a fair trial, which includes impartiality and the right to be heard before a competent tribunal. Yeah? When you look at the International Covenant on Civil and Political Rights, ICCPR, particularly Article 14, it mandates that trials be held by independent impartial tribunals, which military courts often fail to make due to what? Excessive executive influence. Not so. And that's something you must understand. So the African Commission on Human and People's Rights has consistently condemned the trial of civilians in military courts as a violation of fair trials. Look at the case of Media Rights Agenda versus Nigeria, Commission number 224 of 1998. That would bring up some of those nitty-gritties that you may want to comprehend. By way of implication, we could argue that civilians can no longer be subjected to court trials, effectively dismantling a long-standing practice. Isn't that wonderful jurisprudence? Perhaps we're seeing jurisprudence changing. Not so. Now, cases of civilians previously tried under this provision may be reviewed for constitutional violations. Yeah? And that is, again, a dicey one, because now we're going to get into certain aspects that we need to comprehend here. Yeah? So wait, I want your minds to work. Let me not lose you, right? We're going to talk about the principle of prospective annulment, yeah? Which is a legal compromise. The principle of prospective annulment argues, let me begin with what my friend, the Honorable Justice Chibita said. Justice Chibita applied the principle of prospective annulment, meaning that past decisions of the court martial will not be interfered with, but the ruling will affect future cases. Yeah? Fair, not so. The legal justification for prospective annulment is simple. Courts sometimes apply prospective annulment to avoid legal uncertainty and systematic chaos, as seen in Kenya's Supreme Court ruling of Samuel Kamau, Micharia versus Kenya Commercial Bank of 2012. Yeah? So, while retrospective annulment could actually invalidate numerous past military convictions, prospective annulment ensures a smooth transition without destabilizing the judicial system. And that is something, again, you cannot take away from the word go. Not so. Now, let's also argue in terms of what they call critical evaluation. Yeah? Now, the decision creates what they call a pragmatic compromise but raises concerns about future justice for those previously convicted under unconstitutional systems. Yeah? So it will be prudent for Parliament, for example, to establish a review mechanism to reassess past cases on a case-by-case basis. That becomes a dicey one. Okay? Because then who will benefit and who will not benefit? And what will be the yardstick in terms of measuring that particular issue? Yes. Now, let's talk about the Supreme Court petition in terms of military court trying cases, which are triable before the High Court. Chief Justice, wonderful Chief Justice, Justice Alfonso Owen Doro, made this proposition. He has ruled that the General Court Martial hearing cases triable in the High Court is unconstitutional. Yeah? And he's simple. In terms of the legal analysis, he argues in light of Article 139 of the Constitution, which vests unlimited original, the word is original jurisdiction in what? In the High Court. Yeah? So the Supreme Court ruling in, for example, Uganda Law Society and Jackson Karugaba versus Attorney General, which is 2009, held that military courts cannot usurp the High Court's jurisdiction over serious crimes. Yeah? So let's put things squarely where they're supposed to be. Yeah? Even if we argue in light of the African Commission decision on Civil Liberties Organization versus Nigeria, which is 1999, it condemned military courts' intrusion into civilian judicial functions. And that is something you must understand again from the word go. By way of implication, we could argue and say that this particular issue solidifies the High Court's exclusive jurisdiction over serious crimes, including terrorism and treason, by the way. Yeah? So the idea is that all pending military trials of civilians of High Court offenses must be transferred to where? To civilian courts, including the one of who? Dr. Kiza Besigye. Remember that, including the one of my former student, Counsel Aaron Kiza. Now listen, unconstitutionality in terms of trying civilian in military courts is something that is super important. In fact, the Chief Justice categorically declared that the trial of civilians in military court is unconstitutional and dismantles a long-standing practice. That is something super important. Listen, in terms of legal and human rights consideration, the ruling enforces the principle of civilian supremacy over military justice. Yeah? And therefore, it aligns Uganda's legal framework with international human rights standards, ensuring civilians receive fair trial before competent civilian courts. That is super important, my friends. The law is catching up with us. Not so. The long arm of the law is catching up with us. Let's argue in light of the broader constitutional inconsistency of the court martial proceedings. Yeah? Court has actually found that all general court martial proceedings are inconsistent with the Ugandan constitution. And that was that icing on the case by Justice Bongewere Kasi. Not so. Super important. Not so. And the argument here is that, in light of the consequence, is that this has actually paved the way for a comprehensive reform in terms of Uganda's military justice system. Yeah? And therefore it requires the amendment of the UPDF Act to align in terms of military, strictly within constitutional principles. So this argument that we are untouchables is no longer a case anymore. Everything has to be subjected to what? To the Constitution. Any other law that is null and void will be inconsistent to the extent of its consistency. Not so. In terms of broader political and human rights implications, the ruling basically comes amidst cases involving political figures like Dr. Kiza Besigye, like I told you, highlighting the misuse of military courts for political suppression in many cases. Yeah? And the implication of the rule of law and governance. Yeah? And therefore reinforcing judicial independence by curbing executive overreach through military trials is something we have to address. And perhaps that's what the court is trying to make in terms of a serious affirmation. And therefore it is setting a legal precedent that protects opposition figures, for example, from politically motivated prosecution. Yeah? Which is substantially important. And therefore it is also aligning Uganda with international best practices on civilian judicial protection, which is substantially important. But and if you to argue by way of a way forward, we could argue in terms of judicial foresight, or oversight for that purpose in terms of legal reforms. Yeah, we could argue in terms of strengthening civilian judicial oversight. Yes, Parliament, for example, as promulgators or as people who are given the mandate to enact laws, must enact new laws regulating military courts within constitutional boundaries. Parliament, do your job. Parliament, do your job. Yeah, the Judicial Service Commission should establish clear oversight in terms of this mechanism as well. Yeah? And then the argument of establishing what they call civilian review panel. Yeah? It should also be thought about. This is food for thought. The review panel should actually be created to examine past wrongful convictions under military jurisdiction. Substantively important. This happens everywhere, by the way. Yeah? Addressing those, those past wrongs, perhaps, that were inadvertently or whatever done, And then we could argue in terms of advocacy for legislative amendment. I just said that the UPDF Act itself should actually be amended to restrict military court jurisdiction strictly to military personnel. Yeah? So that, it goes within their ambit, rather than, involving people substantially under the guise that they are acting, military, yet they are not. So the argument here is that this is a landmark case for constitutionalism. And as a student of constitution myself, as a lover of constitution in myself, I would argue that the Supreme Court ruling in Attorney General versus Kabazuruka is a landmark decision that reinforces civilian supremacy over military courts as an aspect that you cannot take away. It also creates an aspect of what they call judicial independence. That's an aspect that you cannot take away. It also argues in terms of constitutional protection of fair trial rights, which you cannot take away again. I think it was Dr. King who said that if you do not defend the Constitution, then the Constitution will have no right to defend you anymore. And also it creates the aspect of the necessity for legal reforms to align military justice within constitutional principles. So that all what we do, all these so-called arms of government, whatever they may be, are within the ambits of the rule of the law, as enshrined in the Constitution. So the ruling moves Uganda basically, in my opinion, closer to international human rights standards, setting a precedent for military justice reforms across Africa, and no doubt that this ruling, by way of declaration, in terms of a trial, in terms of these civilians in military courts, has been unconstitutional anyway, and has significant implications, even on past convictions. So while the court decision establishes that civilians should actually not be subjected to military tribunals, it does not automatically, I know, overturn the previous convictions handed down by such courts. And that's the lacuna we may have here. But I just say that Justice Jimita had an escape route for us in light of judicial precedent. But individuals who are tried, for example, and convicted as civilians in military courts may now have grounds to appeal in terms of their convictions. And these appeals would actually need to be filed within appropriate civilian appellate courts also, where each case would actually be evaluated based on specific circumstances. And such, the success of such appeals will actually depend on various factors, including the nature of the charges, for example, or evidence presented, for example, or even the legal arguments made. And that's another dicey one, So it is important to note that the legal process for challenging past convictions can actually be complex, It can actually be time consuming. And the affected individuals are even advised to seek substantive counsel from people, legal experts, in terms of how the appeals or retrials can actually be ensured in terms of these civilian courts. So the ruling basically underscores the importance of adhering to constitutional principles, ensuring that all individuals receive fair trial within the appropriate legal judicial framework. And the legal system adjusts to this decision. It's anticipated that there may be further developments regarding review or potential, overturning of past military court convictions involving even civilians, and that's a debate that we may have at the end of the day. So, my friends, this makes another change in the jurisprudence of our country. And as a legal realist, I believe in evolving of the law, and this is something that excites us as constitutional scholars in light of what has happened today. Once again, my name is Isaac Christopher Lubogo. Find many of our books at lubogo.org and suegeneslawapp.com. God bless you, and thank you for your attention.